Morning, everyone. If you'll take your seats, thank you. Today's Tuesday, August 6, 2024. It is 9 a.m. We are here in the City of Cape Coral Council Chambers for the hearing examiner hearings. As you can tell from my voice, I have a bit of a cold, so if at any point during your hearing you don't understand what I'm saying, please feel free to say, "What did you say?" So I apologize for that, but sometimes life gets in the way of other things. So we're here today for the hearings, and before we start, I have a few preliminary comments. I normally have my little script out, but I was too busy getting my cold medicine out. So here we are. As I mentioned, for the hearings, the hearing process that's followed in the City of Cape Coral is a little bit different than that followed in other jurisdictions. And so I want to acquaint you, if this is your first time here, with how our process works. In the Cape Coral process, the clerk will read the introduction to the case, and the clerk will then swear in anyone who is testifying. City staff will then testify regarding compliance with public notice, assuming the public notice has been properly found. I think we're a little too hot on the microphone, John. Thank you. Assuming public notice has been found, the applicant goes first and is required to present an entire case. In other words, to address all of the aspects of the city ordinances and other statutes and rules. Following the applicant's presentation, the city staff goes second and presents their case. Public comment is next. If you're here for public comment, please be sure to fill out a public participation card. The function of that is so we can spell your name correctly. If you wish to have a copy of the hearing examiner's recommendation or order, as the case may be, please do put down your email address. However, if you put down your email address, please be aware of the fact that it becomes public record at that time. In any event, if you're here for public comment, please make all of your comments comprehensive, because once public comment is closed, it will not be reopened. Applicant will respond to questions following the closure of public comment, and also the applicant will make any final comments. Staff will do the same, and then the hearing will be closed. If you have a cell phone with you today, please silence it or turn it off if you can. And if you wish to have private conversations, I would suggest that you take those outside the room. These microphones are pretty powerful, and if your comments or your conversations are picked up, they then become public record as well. Please come to the microphone if you have comments to make, so we can properly record your testimony. All testimony must be under oath. I think that pretty much comprehensively addresses all the preliminary comments I have, and so I will turn to our very capable clerk and ask her to call the first case. Thank you.
Case number VAC 23-000018, address 921 Dolphin Drive, applicant Pedro A. and Angela Marcusi. A vacation of plat is requested by the owners of a property with single-family residential R1 zoning at 921 Dolphin Drive. This property has an existing single-family house. The site abuts the Dolphin Canal to the north of the site. The owners request to vacate 2,802 square feet of unexcavated canal right-of-way and 480 square feet of platted easements along the north property line of the site. These vacations will allow the owners to proceed with obtaining a permit for a new marine improvement. The city will retain easements sufficient for maintaining a continuous perimeter easement around the site. This request, if approved, will have no adverse effect on boater navigability or safety in the Dolphin Canal. Staff recommends approval. Any persons giving testimony today, if you are able, please stand and raise your right hand. Do you solemnly swear or affirm to tell the whole truth and nothing but the truth? Thank you. Thank you.
Thank you, Madam Clerk. Good morning, Ms. Ford.
Good morning, Madam Hearing Examiner. For the record, Candace Ford, planner with the City Planning Division. I'm just here to confirm that this was properly advertised. We did place a sign on site. All mailers were sent to residents within 500 feet of the address, and then an article was also posted in the news press.
Thank you. Everyone will find the proper notice was given. Thank you. May we have the applicant's representative up, please? Thank you.
Yes, good morning. My name is Pedro Marcucci. I'm a retired physician, and just recently we applied for a permit to do some improvements on our repairs actually on our dock. This was denied because we don't owe the property adjacent to ours. So we are applying for a vacation of the plat north of us, which is approximately 2,800 meters. That abuts to the Dolphin Canal.
Okay, thank you. Is there anything else you'd like to say?
Nope.
Well, hang on, because I have to ask you a couple of questions. As I indicated in my introduction, there's an entire set of city rules and ordinances, et cetera. Have you had an opportunity to review the staff report?
Yes, ma'am.
Do you agree with the staff report?
Yes, ma'am.
So if you incorporate the staff report into your presentation, all those things I just mentioned, you will have successfully addressed.
Thank you, ma'am.
How do you feel about that?
Great.
Okay, so you do want to incorporate. And I have one more question. Did you have an opportunity to review the email from Mr. Malazewski?
Yes.
Do you have any, you don't have to comment on that, but if you choose to, this is your opportunity to.
No, I have no comments.
Okay, and what I'm referring is Richard Malazewski had, if I'm pronouncing it correctly, had sent an email regarding the tree fund, so.
Sure.
Okay, I have no other questions.
No, ma'am.
Thank you very much.
Thank you.
can have a seat, thank you. All right. Could we have staff up, please? Thank you.
Good morning again. Once again, Candace Ford, planner with the City Planning Division, here to talk about vacation 23-000018. The owners are going to be Pedro and Angela Marcucci, and they're proposing to vacate 2,802 square feet of canal right-of-way, along with 408 square feet of platted easements in lots 21 and 22. The location is going to be 921 Dolphin Drive, lots 21 to 22, block 14, unit 1, part 2. As you can see, the address is going to be highlighted on the screen in red, and then along with where the general location is in the southeast Cape Coral. It does have single-family zoning, as do all properties within 500 feet of the site as well. A little bit of background about the site. It is currently 9,255 square feet. It does abut the Dolphin Canal, which has a platted width of about 200 linear feet. And it will be noted that their property is about 1,000 feet away from the yacht club. The owners are requesting the vacation to expand their site and bring their property line all the way down to their seawall, like most other properties in the area. The water body is actually a saltwater water body as well. The minimum standards pertaining to the site is that the petitioners do have color of title to the parcel covered by the plat for which the vacation is being requested. Correspondence from utility providers were obtained and submitted with the documents, and then sketches and accompanying legal descriptions for the right-of-way and easements requested to be vacated were also submitted. And now for the analysis for LDC section 3.4.5.b. Standard 1 is whether the plat, easements, or right-of-ways are required by the city for any future transportation, access, water management, or public utility purposes. Currently, this is a strip of unexcavated canal right-of-way that's roughly on average about 35 feet in width, compared to the most canal right-of-way vacations. Like most property owners nearby, their property line does extend all the way to the canal. This particular owners do not, so they're proposing to vacate it to bring their property line all the way down to the canal right-of-way. Based on the location of the right-of-way, it does not have any foreseeable value to the public since it's rather small and it's isolated in its location. Platted easements proposed to be vacated are not needed. The city will retain easements underlying the vacation right-of-way sufficient for maintaining a 6-foot wide perimeter easement around the expanded site. Standard 2 is whether any required easements are necessary to accommodate the vacation of any plat, easement, or right-of-way. Staff finds that no new easements are needed. The city will be able to maintain and retain an easement underlying the vacation right-of-way to provide the 6-foot wide utility easement required. Standard 3 addresses if alternative routes are required or available that do not cause adverse impacts to surrounding areas. Staff finds that alternative routes are not needed, the canal right-of-way being vacated involves unexcavated lands. It's in the canal, or it's in the upland portion, so it's not going to affect anyone traveling along the canal basin, and it will not result in a closure. Standard 4 is if the closure of a right-of-way negatively affects areas utilized for vehicles to turn around and exit an area. Staff finds that the vacation involves a small area of unexcavated canal right-of-way. No vehicles are typically going to be back there, and with the closure, it's not going to impede navigability for boats traveling along Dolphin Canal. Standard 5 is whether the utility providers gave consent to the vacation of plat, easements, or right-of-way. Staff did find that all 3 utility providers did provide letters of no objection. LCEC does require a continuous perimeter easement around the site, which will be from the city as well. And then CenturyLink states that if any of their facilities are found and damaged during construction, the owner shall be required to repair those facilities at their expense. Both stipulations do appear in the staff report and conditions of approval. Now we're going to talk about the comprehensive plan for the future land use element. Policy 1.15 Table 1 does show that R1 zoning is consistent with the single-family future land use classification. And then policy 1.15.A requires sites of 10,000 square feet or greater, limited densities of 4.4 units per acre. With the expansion of the site, it will be roughly 12,025 square feet following the vacation. This will equate to a density of 3.6 dwelling units per acre, which is less than the required 4.4, so it will be fine for that. Staff is recommending approval with conditions. The correspondence, as noted, I personally did receive correspondence yesterday regarding the tree fund specifically for this site, but nothing in regards to the actual vacation request. And we do have some conditions of approval, and I'll run through them quickly. Number 1 is the vacation of the canal right-of-way adjacent to lots 21 and 22 shall be consistent with that shown in the sketch and accompanying legal description entitled Sketch to Accompany Description, Vacation of Canal Right-of-Way and Proposed Public Utility Easement, prepared by Wills Service Group, LLC, dated February 2nd, 2024, and it's going to be noted as Exhibit A. The second condition of approval is that the vacation of platted easements occupying lots 21 and 22 shall be consistent with that shown in sketch and accompanying legal description entitled Sketch to Accompany Description, Vacation of Easement, prepared by Wills Service Group, LLC, also dated February 2nd, 2024, and that will be Exhibit B. The third condition of approval is the city shall retain easement sufficient for maintaining a 6-foot wide public utility and drainage easement with the perimeter of the owner's expanded site as depicted in the sketch and accompanying legal description, sketch to accompany description easement proposal dated June 21st, 2024, and that will be Exhibit C. Condition 4 is in the event CenturyLink facilities are found within the vacated area, the owner shall bear the cost of relocating said facilities to new or existing easements at the owner's expense. In the event CenturyLink facilities are damaged within the vacated area, the owner shall bear and repair and relocating said facilities at their expense. Condition 5 has been scratched out because it has been addressed in Condition 3. So condition 6 or 5, depending on how we're looking at it, is in order to ensure that this vacation complies with the city's duty to hold certain platted lands in the trust for public interest, the owner shall make a one-time non-refundable contribution totaling a minimum of $2,800 into the tree fund. The city may use these funds to acquire trees on property owned by the City of Cape Coral to enhance water quality or any other appropriate purposes in accordance with the Cape Coral Land Development Code. The general tree fund contribution shall be paid to the city prior to advertising the hearing of the adoption of the resolution, approving this vacation request. In the event that the city council does not approve the vacation request, the city shall return these funds to the owners, Condition 7 is that the owners shall reimburse the city of Cape Coral the cost of recording this resolution with the Office of the Lee County Clerk of Court. And Condition 8 is that the city shall record this resolution with the Office of the Lee County Clerk of Court following the receipt of the recording fees from the owners. And I will stand by for any questions.
Yes, have you had an opportunity to review the email from Mr. Malazewski?
Yes, I did.
Do you have any testimony regarding it? You're not required to provide testimony, but you can if you choose.
I can touch on it briefly. So, as noted, this is vacation 23. So that does mean that it came in the year 2023 before we did have a tree fund kind of formula set in place. That took place in January of 2024. So that's kind of why there's a discrepancy.
Okay, thank you very much. I have no other questions. This is a public hearing. Are there members of the public who wish to provide input or testimony? Yes, sir, come on up. And would you identify yourself, please, sir? Thank you.
Good morning, Your Honor. My name is Eric Feichthaler. I'm the managing partner of Baran Adamski, Feichthaler and Sanchez Law Firm here in Cape Coral. I'm here primarily on the next item on your agenda, Your Honor, but I did want to speak relating to this one, as all three relate to vacation of rights-of-way, and specifically in this item, Condition 6, which is the tree fund you were just discussing. So I don't have all the facts of this case, so I'll make an assumption, again, that this application was made in 2023 before the fund even existed. I also presume as a result of that, that the applicant was unaware that a potential contribution needed to be made or potentially would be requested to be made for a condition of approval for this vacation. Just to talk a little bit about what we're trying to do. You saw the chart that was up there relating to the lots in this area. You can see it looks like someone's very uneven. I just want to put on the record that the city really should look into taking on its own initiative to correct this issue. As you know, Your Honor, this is happening throughout the older parts of the city. There's an incredible amount of expense and time, both on the part of applicants and on the part of the city, to resolve these issues. I think the city could much more efficiently deal with this and kind of put the whole issue to bed. The current land use regulations relating to vacations of right-of-way do not discuss the payment into a tree fund in any way. And as you know, precedent here in the city has been there has been no such payment. There's been an application fee, advertising fee, but never a fee required to make those, to have that be released. The end result is, and just like this property, there's no change to the actual physical property. There's going to be no removal of trees. There's no harm to the public. And as the staff mentioned, there is no benefit to the city for having this. In fact, the applicant, in this case, my applicant, installed their own seawall or bought a property with a seawall. The city has no maintenance responsibilities for it. And if there had to be maintenance, it would be on the part of the applicant, not the city. And the city does retain its 6-foot public utility and drainage easement in case that were to come up. Through a public records request, I did get draft language that talked about this potential payment, but it talks about how a payment needs to be established for receiving developer contributions. Seems to me it's much more on a larger scale what is apparently trying to be done by the city and not a single-family residential property. It's just trying to correct an error from 50 years ago. So we request that Your Honor consider not recommending or removing Condition 6 in its entirety from this application and not require the $2,800 in this case to be paid. Thank you.
Thank you very much. Are there anyone else? Come on up, sir. I believe you were sworn in as well, so.
I was.
Yes, sir. Could you state your name for the record, please?
Yes, ma'am. My name is James Lear. I'm
I'm sorry, could
resident
you-
of
I'm
Cape
sorry,
Coral.
say it
James
again.
Lear, L-E-A-R.
Thank you.
I'm a resident of Cape Coral. I'm also a certified residential contractor. My credentials are on file with the city of Cape Coral. I support exactly what the attorney just said there, former mayor. I'd also further state that I support the vacation of said property, and I disagree with the dollar amount. I did some public research on the city's website, and the one thing that I noted is prior to this case, as far back as I can see, prior to that case, and I think perhaps one case after their case, or it's very vague. The city website's not very clear because there's not a lot of information. They put some of the vacate files on there, but some of them they're not. They're not in consecutive order, and you just can't find them. But what I did learn from about 10 or 12 of them that I did find is that there's no fee establishment prior to this case, zero. So I also did some research on this general tree fund. I can't find any information on general tree fund in ordinance or anything. I don't know how the math came out with the numbers, and I would also disagree with the math. The two that I did find, which are already paid, were $2,800. Those were commercial properties, to the best of my knowledge. And commercial properties otherwise, in most cases, are charged more because they have more impact on the city. I don't see how we'd even get to $2,800 if we compare residential to commercial. And then, more importantly, when we get to my case, I'll get into more. But I do support their vacate. I do not support, I don't think the public at whole would support continuing to make these payments And furthermore, I agree with the attorney that I think the city needs to look at a comprehensive plan to, vacate most of these properties. Look at all the time that we're spending, the fees, the inconveniences. I mean, we're backed up, just like they're backed up, and he's backed up 6 months. So, thank you.
Thank you, and thank you for spending your time coming in today. I appreciate it. Any other comment or public comment? All right, seeing none, I'll close the public comment section of the hearing, bring it back to the applicant. Mr. Marcucci, could I have you up, please, sir? Thank you. You're not required to comment on anything that was said at public comment. If you want to, that's fine. If you don't want to, that's fine.
I don't need to.
Or if you have any other testimony based upon the staff testimony.
No, ma'am.
Do you wish to incorporate the staff testimony into your presentation today?
Yes, please.
Okay, thank you very much.
Thank
That's it. Thank you. Ms. Ford, can we have you up, please? Thank you. Do you have any testimony based upon testimony, public comment?
I do not, no.
Okay, thank you. Do you have any other testimony today?
Not at this
All
time,
right.
no, ma'am.
Thank you. No other questions. Thank you very much. I will take the comments of public comment under consideration. I will recommend that the vacation request, as requested and discussed today, will go forward, but I will consider the comments of public comment in the context of my recommendation. I know time is money. I'm sure that you've spent a few months getting this far, so I will get my recommendation out as quickly as possible. So thank you very much for coming in today. Okay, and I'm closing in the hearing at this time. Can we move on to the next hearing, please, Madam Clerk? Thank you.
Case number VAC 24-000005. Address 849 Montclair Court. Applicant Eric P. Feichthaler, Esquire. The owner, Freedom Boat Company, requests vacating 1,436.11 square feet of canal right-of-way adjacent to lots 30 and 31, Block 23, Unit 1, Part 2, and 1,227.34 square feet of platted easements occupying lots 30 and 31, Block 23, Unit 1, Part 2, property located at 849 Montclair Court, Florida 33904. If approved, the private property will be enlarged by 1,436.11 square feet. Any persons giving testimony today, if you are able, please stand and raise your right hand. Do you solemnly swear or affirm to tell the whole truth and nothing but the truth?
I do.
Thank you.
Thank you, Madam Clerk. Oh, good morning, Mr. White.
Good morning, Madam Hearing Examiner. For the record, Patrick Carlton White, Senior Planner, downstairs in the Department of Development Services. At this point, I would like to acknowledge that this case has been duly advertised. We placed a sign on the property. We mailed property owners within 500 feet, and we placed a legal advertisement in the news press in accordance with adopted policy.
Thank you. I will find the proper notice was given.
Thank you. I'd also like to request recognition as an expert witness based on prior testimony and my credentials downstairs within the city clerk's office.
I will find you to be an expert for purposes of this hearing based upon your CV, which is of record with the clerk, and also based upon your prior testimony regarding issues that are similar to the issues that are presented by this case today.
Thank you, Madam Hearing Examiner.
Thank you. May we have the applicant's representative up, please? Thank you. Good morning again, Mr. Feichthaler.
Good morning, Your Honor. Again, Eric Feichthaler, for the record, attorney from Baran, Adamski, Feichthaler, and Sanchez, representing the property owner, Freedom Boat Company. As I typically will say, and I'm sure at the end of the staff presentation, I will ask to incorporate their comments into the record, always dealing with people like Patrick White, very professional. This was handled in a timely manner, and again, excellently and professionally done. I really appreciate the work of city staff on this. So I will be supporting the recommendations in the report, except for, of course, condition 4 in our case, which talks about the payment. So first of all, I want to talk a little bit about, again, how these unexcavated rights-of-way, they're creating insurance and title issues for hundreds, maybe thousands of Cape Coral residents, and it's all relating to a platting error in the original development, nothing that these homeowners have done. The site in question is and always has been a single-family residential lot. The city will, of course, continue to have access to the rear of the property and the side of the property through the 6-foot perimeter public utilities and drainage easements, so there will be no lack of access from the city as a result. Personally, I've been here for 36 years in the city, and I do love trees, and it's one of the big complaints you hear is that we don't have enough trees in the city. And I was proud to author our tree ordinance back in 2006 that greatly expanded the ability to plant trees. Prior to that, they were illegal in any right-of-way, ironically, but that was allowed to be the case. And so although it can cause issues during hurricanes, as we saw a few years ago, generally speaking, it's nice to have that canopy throughout the city. So I certainly applaud and encourage the city to find ways to increase our tree canopy and continue to be designated as Tree City USA. However, obviously, I think through these payments are not the right way to go about it. In our case, the applicant, based on precedent and the law, paid the requisite application, advertising, and survey fees to do this. They never had any kind of notice of a required contribution to the tree fund. And unlike the last applicant who had a $2,800 cost for 2,800 square feet, the proposed fee for my client is $32,722.11, which is a 2,100% increase on the per square footage charge that the prior person was assessed. So there, in addition to not being authorized to charge these amounts, there doesn't appear to be any kind of procedure as to how it's determined. The term, when I read this, is shocks the conscience. I don't think I've ever said that in a hearing, but to me that number does shock the conscience for due process and is simply not supported. The current section 3.4.5 of Land Use and Development Regulations says the passage should occur when there is no reasonably foreseeable public use for the vacated area, and as discussed, that small strip does not have any reasonable use by the public or the city in the future. Again, I think I noted through a public records request, I received the draft language that was discussed that said there could be the possibility of a tree fund contribution. And again, it says it may be, for instance, and I'll take the exact quote, payment into a program or fund established in the Land Use and Development Code for receiving developer contributions. So even the staff language, the proposed language, doesn't apply to a single-family residential development. And again, this draft language has not been adopted or in any way been presented to our city council. Also, it's a side note, but I think it's even more troubling, is this condition requires the payment of this amount prior to being heard by city council. So my applicant in this case will have to find over $32,000 for the privilege of simply being heard by the legislative body. And the provision does not provide for returning the funds if the council determines a lesser amount or no amount should be paid, only if it's denied. So again, the condition I think is faulty on its face. There is nothing in the actual proposed rules that require the payment be made in advance. And as you know, these types of conditions, if there were a payment to be made or another condition, would be done after the action of the council and not before. In summary, Your Honor, Condition 4 is not appropriately placed on the request, not supported by the Land Use Development Regulations, and the applicant has absolutely had no notice of its possibility. It is in the public interest that residents can rely on the written regulations of the city and 50 years of precedent when seeking actions like this. We ask that Your Honor approve this vacation request in its entirety with the elimination of Condition 4, and I stand by for any questions you may have.
At the beginning of your presentation, you indicated that you were incorporating the staff, I believe, testimony. I just want to clarify, does that mean the staff report?
The staff report, and I expect I will after their testimony as well.
I just want to make sure we were on the record with exactly what you were thinking.
Yes, on both. The staff report, yes, with the elimination of Condition 4, and I was saying that I'm sure I'll agree with everything in their presentation as well, except Condition 4.
Thank you very much. I have
Thank you,
no
Your
other
Honor.
questions. Thank you. Mr. White, thank you.
Thank you, Madam Hearing Examiner. Thank you for the kind words, Mr. Feithauer. This case is VAC 24-5. The applicant or the owner is Freedom Boat Company, being represented by Eric Feithauer Esquire. The property is located at 849 Montclair Court. That's in Block 23, Lots 30 and 31, Unit 1, Part 2. The owner is requesting to vacate a little over 1,400 square feet of canal right-of-way adjacent to those lots, and a little over 1,200 square feet of platted easements occupying the same lots. This aerial depicts basically a zoomed-out aerial view of the subject vacant property. It's in southeast Cape Coral, about as southeast as you can get. The future land use map depicts the property as having a single-family residential future land use designation and a corresponding single-family zoning. Exhibit A, B, and C within your packet execute this vacation. Exhibit A is the requested vacation area depicted in blue. Exhibit B is the proposed public utility easement vacation depicted in red. And Exhibit C is the reservation of the public utility easement over the existing right-of-way area depicted in a purple to reestablish the perimeter 6-foot public utility easement along the new expanded site. As previously noted, the property is zoned single-family residential and has a corresponding future land use designation. The vacation will enlarge the property by a little over 1,400 square feet by vacating land adjacent to the two canals. The owner is eligible to file the request. Staff analyzed this in accordance with policies 3.4.5B 1 through 5 and found the following in response to item 1, that the right-of-way consists of narrow, unexcavated strips of land which lie between the northern and eastern property lines and two canals. That right-of-way is not part of the functioning canal system and doesn't provide any type of mobility or transportation benefit. The applicant has proposed to reestablish a 6-foot perimeter easement around the expanded site. In response to item 2, staff found that sufficient easements will be retained by the city for providing a continuous public perimeter easement. No additional easements will be required. In response to item 3, staff found that the canal right-of-way proposed to be vacated is not part of any functioning waterway system. Navigability and visibility will not be affected, and the vacation should not cause any adverse impacts to surrounding properties. With respect to item 4, staff found that the vacation will not result in the closure or alteration of either canal and should therefore have no effect on the movement of boats traveling in the Monticello or the Monterey canals. In response to item 5, staff notes that we received all 3 utility providers issuing letters of no objection required the vacation. Conditions of approval recommended by staff ensure a perimeter public utility easement around the expanded site. Staff also looked at this proposal with respect to the comprehensive plan and found conformance with policy 1.15 and 1.15A and is recommending approval with conditions. The first being that the vacation of the 1,436.11 square feet of canal right-of-way and underlying easements shall be consistent with that shown in the sketch and accompanied legal description prepared by Harris Jorgensen LLC, labeled Exhibit A. Condition 2, that the vacation of the 1,227.34 square feet of platted easement shall be consistent with that shown in the sketch and accompanying legal description prepared by Harris Jorgensen LLC, labeled Exhibit B. Condition 3, that the city shall retain easement sufficient for maintaining a 6-foot wide perimeter easement around the site as depicted in accompanying sketch and legal description prepared by Harris Jorgensen LLC, labeled Exhibit C. Condition 4, that in order to ensure this vacation request complies with the city's duty to hold certain platted lands in trust for the public interest, the owner will make a one-time non-refundable contribution totaling a minimum of $32,722.11 into the general tree fund. The city may use these funds to acquire and plant black or red mangrove trees on property owned or managed by the city or Cape Coral to enhance water quality or any other appropriate purpose in accordance with the City of Cape Coral LDC. The general tree fund contribution must be completed prior to the advertising the adoption of the resolution approving this vacation request. In the event the City Council does not approve the vacation request, the city shall return these funds to the owner. Condition 5, that the owner shall pay the City of Cape Coral the cost of recording this resolution with the Office of the Lee County Clerk of Court. And condition 6, that the city shall record this resolution with the Office of the Lee County Clerk of Court following the receipt of the recording fees from the owner. That concludes my presentation. I'll stand by for your questions.
Thank you. Thank you very much. I do have a question. You've heard the testimony of Mr. Feichthaler on behalf of his client. You're reading my mind, going back to number 4. Do you have a response regarding his characterization of dubious legality, let's call it that way, of dubious legality, some issues regarding the legality of the imposition of the fund obligation, and secondly, the amount. Do you have any testimony on either of those two, or anything else that he's testified to?
I do. Firstly, we have previously encountered other cases like this where we have required a similar condition. I do note that the amount of the condition may have come as a surprise to Mr. Feithauer and his applicant. The amount is based on a new methodology that staff created to work out. Basically, we wanted to estimate what that land was worth. So we used the Lee County property records to determine an assessed value per square foot and multiplied that value times the requested vacation area and then cut it in half. And that is how we arrived at that particular number.
Do you have any testimony regarding the remainder of his testimony regarding the legality of the imposition of this fee? Or this amount?
I think we could tweak condition 4. Mr. Feithauer did note that the last sentence, that the city shall return these funds to the owner in the event of denial, could be broadened to include language that would allow staff to return a portion. Perhaps the city council didn't want to require that full amount. So we could loosen that condition to allow that to happen more easily.
And as I recall, the prior ones that we've had have been below $3,000. Is this the, excuse me, I'm descending into my cold, I apologize. Is this the first one that has an amount that's larger than $3,000 that's been brought forward?
It's the first 5-digit amount.
That's what I thought. All right. Do you have any other testimony?
No, ma'am, I don't. I would like to incorporate my staff report, the PowerPoint, into the record. I did receive a number of phone calls related to this case. I received, that's not it. Just bear with me, I have a few things in my pocket today. I received a total of 6 phone calls, and I believe there may be some members of the public who, those phone calls, none of them objected. They generally had questions and concerns about what vacation meant, and they did not object or support. They were just looking for information, and I believe we have a few members of the public also that may wish to provide input.
Okay, fine. Thank you very much.
Thank you.
Is this a public hearing, or are there members of the public who wish to provide testimony or input? This is your opportunity, folks, if you want to come up. Well, you'll get there. Hang on, Mr. Feithauer. This is public testimony. If there's anyone in public testimony, any members of the public, I believe that you're the applicant, is that correct, sir? Yes. The gentleman behind you is the applicant?
I'm not related to this case, Your Honor. I'm on another case.
Okay, well, come on up. Come on up. And the gentleman has indicated he's not here as the applicant for this case, so you're here for another case. You were sworn in, I think.
Yes, ma'am. Again, my name for the record is James Lear.
Thank you.
Also, again, certified residential contractor, City of Cape Coral, credentials on file. Again, just advocating for the attorney's case here. I support the vacation of property. What I don't support is item number 4. Again, just to repeat what I discussed earlier is there is, based on my research, there's no legal finding to support this dollar amount. And the one thing that I would say for this case, which is, and not to throw anyone underneath the bus, but coming up with numbers in a meeting doesn't result in policy or ordinance. If you're going to charge, my personal thought, if you're going to charge members of the public for the use of their own property, perhaps that should be a voted upon ordinance. Thank you.
Thank you, sir, and thank you again for coming in today. Are there other members of the public that wish to comment? Come on up. Were you sworn in, ma'am? All right, so our clerk will swear you in before you can testify.
Please raise your right hand. Do you solemnly swear or affirm to tell the whole truth and nothing but the truth?
I do.
Thank you.
And would you state your name for the record, please?
Sure. It's Faith McCormick.
Thank you.
I received the letter because our home is within 500 feet or whatever from the requested vacate. I know that the city has been doing this, and I just want to, and I'm sure it's going to continue to happen. But I think that the result of the city allowing the vacate of these properties is resulting in larger homes being built, closer to seawalls, closer to canals. The reason that, and I think it's pretty presumptuous to think that it was a mistake made 50 years ago. Maybe the reason that there was a large easement was because they wanted to provide the people that lived here the views, not of large homes placed up close to canals so that when you go outside to enjoy your property, that's what your view is, not maybe to allow me to see the sunrise in the morning as I drink my coffee. Maybe not to allow such large homes to be built on these properties that are maybe being used part of the year, I don't know, or maybe all of the year. To say that it doesn't affect the people surrounding those properties that are then, built upon even bigger and bigger and bigger. And if you take a bike ride around the Lower Cape, that's what's happening all along the river and the canals, where the value has just escalated. The reason that we came here, the reason that we narrowed down our future home, our retirement, our everything, and moved here full time to that specific area was because there were the beautiful views that will be taken away eventually by all these homes that are being built and allowed to be built larger because the city will give away the property that had allowed us those views in the first place. So I know it's all about money, it's all about business, it's all about development, but for me, it is not about that. It is about quality of life. And, you may say it's only a little bit, but when you take that little bit on one side and a little bit across the canal and a little bit across the other canal, and you put a 2-story home there that comes all the way out, and then maybe it stretches down the property line even further to allow a bigger boat, it is affecting my quality of life. It is affecting my home. So I just want that to be public record, that the city should consider those who live here and move to that area for a reason, and that those are the reasons. Thank you. Thank you for your time.
Thank you, and thank you for coming in this morning, and I'm sure your time is valuable, and I appreciate you coming in to share your views.
Thank you.
Thank you. Anyone else in the public who wishes to speak? Yes, sir, come on up. Madam Clerk, could you swear in this gentleman? Thank you.
Please raise your right hand. Do you solemnly swear or affirm to tell the whole truth and nothing but the truth?
I do.
Could you state your name, please, sir?
Mark Miller.
Thank you. Go ahead.
Yes, I have the property next to the one in question that they're asking for the vacation. And I strongly agree with Faith that the amount of green space is being swallowed up by these vacations, because the primary purpose when they're building is to enlarge the structures. Therefore, bit by bit, it's constantly being eaten away to where we're losing green space. I would like to gain more green space, have more trees, not remove them, and remove all the green that we have existing, just so they can have a bigger pool or a bigger foundation. So yeah, I strongly object to just giving all these vacations away. Some may be necessary, but in this case, I don't really see that happening. The other thing is in regard to the amount. I certainly understand that's kind of a blow when they ask for these vacations, that all of a sudden they're being hit with this charge. All these things just seem to come up arbitrarily. They just start whacking us if I were to ask for this vacation with these, the funds that have no standard, no business even being in there, in my mind, because of an error made a long time ago. If the error was made by the city, I think the city should be responsible, not the property owners. Thank you.
Thank you, sir, and thank you for coming in this morning and taking your valuable time to comment. Are there any other members of the public who wish to provide testimony? Okay, I'm seeing some frowns on some faces. This is your opportunity, folks, if you want to speak. Ma'am, it's up to you. If you want to come up, that's fine. If you don't want to come up, that's fine. All right, I'm not seeing any enthusiasm for coming up. All right, I will close public comment at this time. Mr. Feichthaler, you're up, sir. Thank you.
Thank you, Your Honor. Just one comment regarding Patrick's comments regarding methodology, which he said, and he paused, he said, staff created. So yeah, everything has to be created by staff at some point, but again, no notice of that creation was ever done. And I would just point out the obvious discrepancy between my client, who's being charged over $22 a square foot, and the prior applicant, who's at $1 a square foot. There seems to be absolutely no consistency in the way that the city is attempting to assess this fee. So again, we are completely against that fee at all and still ask for condition 4 to be removed. But if you do decide, Your Honor, that it is appropriately charged, we ask that it be consistently applied at $1 a foot, which would make us $1,436.11.
Thank you. Did you want to address the comments of public comment? Obviously, you're not required to, but you certainly can.
Well, sure. The one thing that I would say is no trees are going to be harmed with this. In fact, when the construction occurs, there will be trees required by code. And that right now, this applicant and everyone that's here today cannot legally access the water. They have bought a waterfront property that is short, and the prior one was 30 feet short, I think it said, and we're 3 feet short. That is issued, again, there are issues with insurance. It does cause the property to be increased for the building footprint, but it doesn't limit today whether you put a 35-foot high structure there today, whether this is done or not. So I do understand the concerns of the folks that spoke today. There are houses that are going up all over the place, particularly in the older parts of the city. There are tear downs. And there's always conflict between the older homes and the newer homes, but this particular vacation won't really change anything with regard to the value of the home that can be built there. It's simply a matter of being able to access the waterfront that this residential owner should be entitled to do.
Thank you very much.
Thank you, Your Honor.
All right. Mr. White, you're up, sir. Thank you. Any further comments based upon public comment or further testimony based upon Mr. Feichthaler or any other testimony that you choose to present at this time? Thank you.
Just one thing. It was unfortunate that this case and the next case have a different methodology for the tree fund contribution than Ms. Ford on behalf of Mr. Struves. The timing was different. When that case was submitted, we were using a methodology that was based on a per tree contribution. It has now evolved into this new methodology with different results. And thank you, folks, for coming and providing your input on the case. I do appreciate it.
And can you go into a little detail about how the methodology of computation was arrived at? Was it staff? Was it presented? I don't believe it was presented to council. Is that correct?
It has not been presented to council, no, ma'am. It was created by city staff.
Okay, when you say staff, are we talking about community development staff or
Yes.
economic development staff or?
Community development staff.
Okay, I have no other questions. Any other testimony?
No, ma'am. Thank you for the opportunity.
Okay, thank you very much.
Thank you.
All right, I will take everyone's comments under consideration, both the applicants, representatives' comments, and also public comment. If you're familiar with these proceedings, I take public comment very seriously, and I do take some time to contemplate what that is about. Obviously, the applicant's comments in opposition to that condition something I will consider very seriously as well. So I normally say I'll get this out as quickly as possible. Mr. Feichthaler said, sorry to say that due to the fact that I do want to think about everything that's happened here in this hearing, there will be a slight delay, but it will not be a significant delay either way. So with those comments, I am closing this hearing, and Madam Clerk, would you go on to our third hearing? Thank you.
Case number VAC 24-000006, address 1645 Edith Esplanade, applicant James Lear. The owners, Ho Tai and Pham Trang, request vacating 94.2 square feet of canal right-of-way adjacent to lots 34 and 35, Block 75, Unit 6, Part 3, and 416.5 square feet of platted easements occupying lots 34 and 35, Block 75, Unit 6, Part 3, property located at 1645 Edith Esplanade, Cape Coral, Florida 33904. If approved, the private property will be enlarged 945.2 square feet. Any persons giving testimony today, if you are able, please stand and raise your right hand. Do you solemnly swear or affirm to tell the whole truth and nothing but the truth?
I do.
Thank you.
Thank you, Madam Clerk. Good morning again, Mr. White.
Good morning again, Madam Hearing Examiner. For the record, Patrick Carlton White, Senior Planner with the Department of Development Services downstairs. At this point, I'd like to acknowledge that VAC 24-6 has been duly advertised in accordance with city policy. We placed a sign on the property. We placed an ad in the news, a legal ad in the news press, and we mailed property owners within 500 feet of the subject address.
Thank you. I will find the proper notice was given.
Thank you. I'd also like to request status as an expert witness based on cases similar to this that I've previously presented, and my credentials that are on record with the city clerk's office.
I will find that you're an expert with regarding the matters that are addressed in this hearing today based upon your CV, which is of record with the city clerk, and also based upon your testimony regarding issues that are similar to this in prior hearings. Thank you.
Thank you. That's all at this time.
Thank you. All right, we have the applicant up, please. Thank you.
Good morning again.
Good morning, Mr. Lear.
My name is James Lear for the record. I'm a certified residential contractor. My credentials are on file with the city building department. To the left of me is Ty Ho. Mr. Ho is the homeowner. The address concern is 1645 Edith Esplanade and Cape Coral in jurisdictional purposes, Lee County, Florida, regarding VAC 50 and a 6. I'd like to acknowledge professionalism of Mr. White and his office and his team. I found them to be, for the record, very professional. I just want to throw that out there.
We appreciate those comments. We don't hear that a great deal in these chambers, so thank you. I'm sure Mr. White's appreciative as well.
I hope the supervisor's listening. Historics, I'd like to talk to how we got to where we're at, because I'll get to the point at the end. I'm just confused by the whole process, but let me just begin.
You can take as much time as you need, Mr. Lear. There's no
course.
time restriction. Thank you.
Thank you. So how we came to be where we are today is we requested a building permit to build a home, which was approved by the building department. Mr. Ho entered into an agreement with an unrelated pool company to my company to build a pool, 2 separate permits. That pool was approved by the building department, and several inspections had occurred. The homeowner directly next to the home filed a complaint with the building department and stated that this home, to which we were building and was approved, was too far into the setback and was out of compliance with building code and zoning rules. The building department, which gathered up a bunch of people and drove down to the location, soon discovered that there was no issue, and had they just looked at the survey, they would otherwise seen there was no issue, because the survey clearly indicated that there was no issue. In fact, it was later learned that that particular home was actually out of compliance. That home is actually too far to the left. So they filed a complaint on us, only to discover that they're out of compliance. However, the building department did not stop. They went to the back of the residence and then discovered that the pool, that they had previously approved and had many inspections to that point, was now in some sort of setback violation. And that is how we got to where we were. So I'd like to refer you to, I'm going to make several references to both Florida state statute and some others, and I'll clearly define them, but 704.01, elements are provided for the interest of the general public must be likely to affect a segment of the property. This particular issue is on the rear of the residence. This easement is not likely to affect any segment of the property. There are no sidewalks, no parking, no utilities planned for the rear of the property. In fact, the homeowner, just like any other homeowner, has the ability to trespass anyone on his property. Was the land proposed for the vacation currently in use? So there is no penalty for use of any important functions such as utility lines, streets, sidewalks, as indicated by the letters that we received from the utility companies, which are on file. Is the land proposed for vacation involve any future plans? No. Will the property be improved with the addition of the vacated parcel? Yes. The addition of a swimming pool, which is already approved by the City of Cape Coral Building Department, will result in increased use of the property, and this allows for increased revenue to both the city, the council, and the school board by increased value through real estate taxes, which are already established. Would the granting of the vacation allow a valuable land use which is presently precluded in the right-of-way? No, there is no right-of-way requirement. It's not on a street. In fact, there's an established seawall that's currently present and purchased or maintained by the homeowner. Would granting a desired vacation have an inverse effect on the surrounding properties? No, it wouldn't. There are no potential problems or grounds for denial in neighboring land resulting from a vacation. The petitioner, the homeowner, has rights over the property under consideration for the vacation and thus simply wishes to gain the right to build more extensively upon his property, which was already approved by the city, within guidelines of the building code and municipal zoning requirements. The vacation of dedicated land involves the change of ownership from the city to the property owner. The homeowner wishes to revert the portion of land back to the parcel of the property of which it was once part of prior to the establishment of the easement, to which I cannot find any compensation to the original property owners for that easement. So the minimum standards here, the owner is eligible to file a vacation request as the application provides following: color of title ownership, Mr. Ho is the owner. Letters of no objection from Comcast, CenturyLink, and Lee County Electric Cooperative, LCEC. Survey sketches were provided and obviously discussed. The next issue is compliance. So based on the city's own report of the compliance reports, which is dated July 12, 2024, VAC 24-50 and a 6, there are no known compliance issues with this request. However, based on conditions of approval on page 4 of the staff report, there are no issues other than condition number 4. In order to ensure the vacation request complies with the city's duty to hold certain platted lands in trust of public interest, the owner will have a one-time contribution of $21,691.94 into the general tree fund. These funds will be used, in this case, to plant mangroves to enhance water quality. The general tree fund contribution must be completed prior to the advertising, the adoption of resolution approving vacation request. So that means before it can go before council, money must be spent. So it is not in the public interest, in my opinion, and this is what I'm arguing, to barter the homeowner's property rights for $21,691 for a tree fund for which the public can never benefit from. There's no benefit to the public. It starts out with the public interest. There's no public interest to the rear of his property, to which a permit's already been approved. The city and the county, along with other government institutions, will benefit, again, from long-term taxation of the property improvement. So that money otherwise, to support this tree fund, which I'll discuss in a minute, could otherwise be obtained through taxation purposes. The City of Cape Coral Land Development Code isn't, from what I understand, is an unfunded liability, this general tree fund, which is why it's seeking funds from this homeowner and other homeowners. Then perhaps it should be reviewed for public hearing, for public funding, rather than relying on selective homeowners for a barter payment. In other words, we'll give you the rights to your property, to which you already have, if you pay for this tree fund over here. I was unable to locate any information on this general tree fund. Perhaps it's just not listed on the website. And any math formula to determine the fee requested. If this fee is not required by ordinance, my personal recommendation is just for the record, just like, I work in government on my day job, is that the city staff fund this unfunded liability to a budget proposal. Just go before council and go, we're got to support this tree fund is so important. We need to create a fund for it instead of just picking on the homeowner who just wants his own property. There is no rule or requirement, to the best of my knowledge, for this fund. Nothing. I completely disagree with it. And Mr. White said in the previous public testimony that the city shouldn't have any business in this sort of pay-as-you-go fund. Also in public comment, it was previously stated that, these easement requests shouldn't be approved due to green space. There's no green space issues with this particular issue because these are already approved permits. And part of the requirement of completing certificate of occupancy is that this gentleman comply with the landscaping requirements. Larger homes, there's no change by approving this in the size of his home because it's already approved. It's actually already built. We just cannot get a certificate of occupancy because the building department showed up and decided that the pool company, which is unrelated to the home builder, that, well, you can't get a certificate of occupancy, you're stuck until this pool company issue is resolved. Upon establishment of an easement on the original property owner, to the best of my knowledge, because I did a research as best as I could, there's no compensation. So the city never went to every property owner when the city was founded and say, hey, we're going to take your easement and then compensate you. And now the city is requesting what I believe to be, for all of these cases, even a $2,800 option, it's unreasonable compensation. As, again, for no interest to the public other than to provide trees or mangroves, funds for an unfunded liability. Good cause, I support it, but this should actually go through, I think, a budgeting process. And reviewing what limited information is available on the city public website, I learned that prior to December of 2023, there are no fees to vacate a property easement other than filing and processing fees. None. So the $2,300 starts, or sorry, the $2,800 starts. Again, limited research that I could see on the city's website. With commercial properties, and this being residential, obviously commercial is always a larger impact than residential. So I just disagree with it. And checking with other local governments, because every local government website's available, I don't see any, and I've searched, I don't see anything that says you gotta pay fees, other than, regular fees to get to where we are right now, to have a conversation with a person like yourself. Many of the homes next to the property, if you look at this property and you look left, looking to the right is multifamily residential. Looking to the left, most of those are already vacated. They didn't pay any fees. So they have their pools just like we're requesting. There's no extra fees. Florida State Statute 255.22 provides for the return of private ownership of property acquired by deed or for a specified purpose, wherein such purpose has not been achieved or identified in comprehensive plan for a period of 60 months or more. There's no value consideration was given to the owner for the property. So that goes back to the compensation of the original owners of the property. So just based on this Florida state statute, basically, if there's no interest by the public, then it's suggesting by Florida state statute that the property be turned over. Additionally, and spending a couple hours of trying to find some associated Supreme case law from 1915, and I'll spell it MCCUTCHEON versus Terminal Station Communication, and this regards not the rear of the property with a seawall, but the front of the property next to a roadway. And basically the ruling from Stetson University's website is a municipality is not entitled to compensation for loss of public easement in which it does not own. I would just refer to that. Approval of the vacation allows for increased revenue to the city via increased property value through real estate taxes as a result of the swimming pool. There are no potential problems for grounds for denial of neighboring land. The homeowner is already a victim of the pool company, which I called and asked them to come. And I won't name them for slander purposes, but they're not here. So he's already a victim once by the issue, because when I did speak with a representative of the pool company, we didn't read the survey. Okay. There's no responses received. The city is making the homeowner yet again a victim again by what I feel to be is an unreasonable fee to resolve this issue, which is none of his doing. I believe that there's no standing for this condition number 4. I believe that it's unreasonable. It has not been vetted. It's not a legal requirement. There's no ordinance. And I stated before, simply having a meeting and determining a mathematical formula in a meeting does not mean public policy. Public policy, that's, I would put this right up there with, hey, I pulled you over for speeding. Yeah, well, I determined that the fee is now $30,000. The last guy was $2,800. So I'm requesting approval of vacate, no additional fees, 0 fees, removal of the CO requirement established by the building department, which is preventing us from getting a certificate of occupancy for unrelated issue. Eliminate condition number 4 altogether. However, we are willing to somewhat negotiate with the city what we need to do to come into compliance and just get this approved. But we believe that unreasonable fees are not the way to go, not just for us, but any member of the public. Continued approval, allow us to continue to move forward with the pool, which is currently approved as is on the property with an approved building permit and several inspections already completed. That's it regarding that. I did get Mr. White did provide, I'm not sure if I'm supposed to talk at this point about it, but he did present to me a email regarding a homeowner of Vincent Ritter, 1663 Edith Esplanade, who stated that I will not be here at the meeting. I'm out of state. I don't think my letter of response will be there before the meeting is scheduled on August 6th, so I'm emailing you. I object to the variance requested, as I think if granted, it will take up too much of the basin waterway. 2 things. 1, I don't believe that someone can testify before a hearing from email, so I would request that this email not be part of the record or be struck from the record. And then 2, our request has nothing to do with the basin waterway.
The sea was already there.
Yeah, so, Mr. Homeowner, Ty, do you have anything to say? I'm done for the moment.
Hi, Your Honor.
Yes,
Yes,
sir.
from what I understand from all these represent earlier and the public comment and all that. So I respect, with your opinion and your idea and, whatever you support. But from my own point of view, I'm here today just like Jim was explaining. Basically, I hire a pool company as a contractor, separate contractor. So basically, I asked them, you have to do your own survey and stuff on the land before you do all that. So you did all that. So basically, they were telling me that you did a setback on the pool from the seawall to the pool wall is 10 feet. So based on the code, that's what they were told me. So long story short, the people were complaining, next door, and then that's why we're here today. But basically, I have no knowledge on that. Like that little property right there is the city own that, which is I don't know because we have the seawall in front of that property. So all this time I didn't know that the city owned that land. So basically, from this whole situation, I just want to, support the request for vacating the land, and then with the fee, I can do the contribution to the tree company, but not that kind of amount that I can afford with this time with my project. You know what I mean? So, that's our request at this time. Yeah. So basically, we have no knowledge because the seawall is already there on the property with like 30 years now or whatever. We have no knowledge. So taking over the basin water, which is the complaining, it already exists. What am I supposed to do? Tear down the seawall to tuck back where the cities belong? That's impossible. So that's my concern. Thank you.
Thank you, sir. And I do have the email from Mr. Ritter, and I did read it before today, so I understand what you're talking about. Mr. Lear, I do have two questions for you. Question number one is, you said your request is that there be no more fees imposed. If city council determines, and I don't know what city council will do, they're outside of my knowledge. If they were to make a decision regarding the tree contribution request by staff, and if they were to set it aside, once again, I'm not saying they will. I have no understanding at all of what their perspective would be. You said no fees. There is a fee associated with recording the documents.
Oh, that I would not have an issue with. I did review, like I said, like 13 cases, and those recording fees are in compliance.
Okay, so your testimony would be, when you say you're objecting to paying any further fees, it would be related to the tree contribution, not?
Yes, ma'am.
Okay.
Yes.
I hate to be
Any
picky.
others, and I do apologize. Any other fees, I would concur, they're just reasonable, and it would be unfair to members of the public to have to pay the fees for Mr. Ho's property adjustment there. So,
Okay, and I hate to be picky, but that's my job.
Yes, ma'am.
So I appreciate your candor. Secondly, you said that you're willing to negotiate. If there's something you wish me to consider, this is a time for you to put
May I
on the.
speak briefly just for a moment with the homeowner for a second?
Yeah, why don't you step back so I don't hear
Yes.
your comments. All right, we'll go into recess for 5 minutes. It's 10:13. We'll be in recess to 10:18. Thank you. It is 10:18. Mr. White, could you possibly have the folks out in the hall join us so we can go back on the record if they want to join us? Thank you. Mr. Lear, I believe that you're still up, but let's wait until, if those folks want to join us, let's wait and see if they reemerge. Thank you, Mr. White. Okay, Mr. Lear, you're up, sir. Was there anything further you wish to testify?
Yes, ma'am, I'd just like to follow up.
At the microphone, please.
May I approach?
For what purpose?
I'm just approaching here, that's all.
Oh, no,
Yeah,
that's
no
fine.
worries.
Sure,
Just getting your permission.
that's fine.
So your follow-up question is, what do we believe would be inappropriate for negotiational purposes?
No, that wasn't my question. My
Yes, ma'am.
question was, you referenced negotiation, and I said, if you wish to negotiate, and if you wish to present the results of that today, that's fine, and if you don't, that's fine too.
Yes, ma'am. I'd just like to make one statement, that's all. So my homeowner has agreed to be consistent with the previous case of $1 a square foot, which in our case is about $945. However, the homeowner is willing to do that, and I support the homeowner. So if Your Honor, if you were to come back and say, hey, this is, we would just do that. However, just for the record, I just don't think it is appropriate to be establishing standards for which council has not established through public policy to establish set rates for set things which have not been educated properly in the public or before council. However, just to appease and get this gone, because we're already delayed 6 months, and as you stated earlier, time is money. $945 would be appropriate for the homeowner.
Yes, sir. To pursue the thought a little bit further, I believe you raised some concerns about prepaying that amount. Just so I understand your perspective, so I can properly
Yes, ma'am.
represent the council, are you in agreement to prepay that amount, or are there other elements of this condition that you feel not appropriate? Mr. Feichel, I can't help you.
We would tend to agree with the previous case, which is the standard of paying before going to council. I could see a fee, like a smaller fee, like the time, like we did here, we had to pay a fee to come here, to pay a set unknown fine or requirement for nothing that's not actually established. I would rather go before the council and see what the council has to say and then make the payment.
Okay, so now you've just confused me. You're offering $945 on behalf of your client.
Yes,
I get that part, but now you're saying you want to go in front of council. So just so I'm clear on what you're saying, would you be in agreement to the $945 being paid in advance, or you just want to offer that amount and do a presentation to council regarding the remainder of that condition? It doesn't matter to me. I just want to understand what you're saying.
Sure.
We can do that in advance.
The homeowner would have no problem paying the $945 as long as it's refundable, provided, it's not approved.
Yeah, I understand that.
These
So,
things, yeah.
I'm sorry, I didn't mean to cut you off. Go ahead.
No, that's it.
Okay, I think I clearly understand what you're saying, and I appreciate your additional comments. I have no other questions at this time. Obviously, we still have the remainder of this hearing to address. But, sir, is there anything else that you would like to say, sir?
No. So, just like he said, we all agree with that. So basically, with the $945, as a homeowner, it's pretty reasonable for me. I can afford it to do that. I can pay in advance before to meet with the council, as whatever is possible. And I just want my project to continue on my house, because I've been sitting around for like 6 months now. That's all it is. Basically, it's hurt my mental and my everything, you know what I mean? I'm stuck. So that's why I'm here today. Just want to, do whatever I can just to get things going.
Thank you, sir.
Thank you, Your Honor.
Thank you. Mr. Lear, is there a code compliance case in this matter?
Not that I'm aware of. It was just a telephone call of, hey, you're outside of compliance and you need to do a variance.
Right, and I understand that the certificate of occupancy has not been issued.
Right.
I get that.
We were told we have pulled some inspections, some minor inspections, but we were told ultimately that we cannot get a certificate of occupancy. He cannot move into the residence until this pool issue is resolved.
I'm familiar with how that works, but thank you for that clarification. I appreciate it. All right. Mr. White, sir, you're up. Thank you.
Thank you, Madam Hearing Examiner. Again, for the record, Patrick Carlton White, Senior Planner, DSD. This case is VAC 24-6. Can I get the floor computer, please? Thank you very much. The owners, Hotai and Pam Trang, the representative, James Lear, Ohana Custom Homes. The property is located at 1645 Edith Esplanade. That's in Block 75, lots 34 and 35 within the Cape Coral subdivision. The owners are requesting to vacate 945.2 square feet of canal right-of-way adjacent to the property and to vacate 416.5 square feet of platted easements occupying the same property. Again, about as far southeast as you can get within the city, on the Bikini Basin is the subject lot identified here in red. The future land use of the property indicates that the property has a multifamily future land use designation and is actually zoned multifamily, as well as are all of those properties along said basin. This vacation will be executed with 3 exhibits. Exhibit A depicts, depicts the proposed vacation area in blue. Exhibit B depicts the proposed PUE vacation in red. And Exhibit C depicts the proposed PUE reservation in purple, all functioning together to reestablish a 6-foot perimeter public utility easement should this vacation be approved. I previously relayed the future land use and the zoning of the property. I'll note also this vacation would enlarge the area of the property by vacating upland canal right-of-way, that the owner is eligible to file the request, and that a single-family home was demolished in 2021. A new home is under permit in 2022, and staff analyzed this in accordance with 5 criteria found in 3.4.5. Criteria 1, staff found that the right-of-way consists of a narrow, unexcavated strip of land lying between the north property line and the seawall. That right-of-way is not part of the functioning canal system nor the basin, and therefore does not provide any sort of mobility or transportation benefit. Staff also notes that the applicant will provide a 6-foot perimeter easement around the expanded site. With respect to criteria 2, staff found that sufficient easements will be retained by the city for providing a continuous public utility easement around the expanded site. No additional easements would be necessary. Regarding criteria 3, staff found that the canal right-of-way proposed for vacation is not part of any functioning waterway system. Navigability and visibility will not be affected, and the vacation will not cause adverse impacts to surrounding properties. Regarding criteria 4, staff found that the vacation will not result in closure or alteration of the canal and will therefore have no effect on the movement of boats within the Bikini Basin. Regarding item 5, staff found that all 3 utility providers issued their letters of no objection. LCEC did note that a continuous easement would be provided. Conditions of approval recommended by staff will ensure that this perimeter easement is provided. With respect to the comprehensive plan, staff found consistency with policy 1.15, identifying the zoning as compatible with the multifamily future land use, as well as policy 1.15.a, finding that the proposed density of this site is well below the maximum allowed 25 per the multifamily future land use classification. Staff's recommending approval with a number of conditions. The first, condition 1, stating that the vacation of the 945.2 square feet of canal right-of-way and underlying easement shall be consistent with that shown in the sketch and accompanying legal description prepared by Davis Surveying Incorporated labeled Exhibit A. Condition 2, that the vacation of 416.5 square feet of platted easements shall be consistent with that shown in the sketch and accompanying legal description prepared by Davis Surveying Incorporated, labeled Exhibit B. Condition 3, that the city shall retain easement sufficient for maintaining a 6-foot wide perimeter easement around the site as depicted in the accompanying sketches and legal description prepared by Davis Surveying Incorporated, labeled Exhibit C. Condition 4, in order to ensure that this vacation request complies with the city's duty to hold certain platted lands in trust for the public interest, the owners will make a one-time non-refundable contribution totaling a minimum of $21,691.94 into the General Tree Fund. The city may use these funds to acquire and plant black or red mango trees on property owned or managed by the city of Cape Coral to enhance water quality or any other appropriate purpose in accordance with the City of Cape Coral Land Development Code. The General Tree Fund contribution must be completed prior to advertising the adoption of the resolution approving this vacation request. In the event the City Council does not approve the vacation request, the city shall return these funds to the owners. Condition 5, the owner shall reimburse the City of Cape Coral the cost of recording this resolution with the Office of the Lee County Clerk of Court. And Condition 6, the city shall record this resolution with the Office of the Lee County Clerk of Court following the receipt of recording fees from the owners. I would note at this time, staff does not object to broadening Condition 4 to basically reflect that should the council wish to only collect a portion of that amount, then we could return that if necessary as well. At this time, I would also like to request that the staff report and the PowerPoint be incorporated into the public record. And with that request, I will stand by for your questions.
Thank you. My first question, Mr. White, is with regard to the email that you forwarded to me from Vincent Ritter of 1663 Edith Esplanade 33904. And as indicated by Mr. Lear in his presentation, the contents of that, I'm going to cut to the chase because there's some preliminary stuff about how he can't attend the hearing. I object to the variance requested, as I think if granted, it will take up too much of the basin waterway. Do you have a comment upon that statement?
I do. I believe that the writer perhaps misunderstood what was being requested. This vacation, if approved, will not intrude into the Bikini Basin. It is only for upland canal right-of-way depicted in blue.
Thank you. I assumed that you were going to say that, but I want to get that on the record officially.
I appreciate the opportunity.
Now, you've heard a very thorough presentation by Mr. Lear quoting state statute, which in some ways tracks what the city ordinance says. Actually, vice versa. The city ordinance tracks what the state statute says in some ways. Do you have any testimony you'd like to present on any issue raised by Mr. Lear this morning in this hearing? And you don't have to, but if you choose to, that's fine.
I suppose for the record, we should have a brief dialogue about Condition 4 that was previously held on the last case. Only to reiterate that the Condition 4 was based on a methodology that city staff created. We believe that the condition was well-crafted and legally good. I appreciate their perspective, and Mr. Lear noted a number of times that this was their own private property. I don't believe that's completely accurate. While it is partially theirs, it's also overlaid with the city right-of-way for that canal and that basin. And with those few notes, I don't believe I have anything else to add.
Thank you. I have no further questions. This is a public hearing. Are there members of the public who wish to provide input or testimony? Mr. Feichthaler, you've been very patient. We've been here for an hour and a half, so.
Well, thank you, Your Honor. You have as well. For the record, Eric Feichthaler, attorney at Brand, Adamski, Feichthaler, and Sanchez. Just briefly, we'll say, when you apply the law to the facts presented today, to me, condition 4 should be absolutely removed. I know we've talking about kind of negotiations and maybe it should be less. I don't believe that it's appropriate under our current regulations to have condition 4 in any way. No notice have been given to the applicants. People need to have a certain amount of confidence that they know what they're getting into when they make an application, spend the time, spend the money to get to this point. As everyone's pointed out today, everyone has spent probably 4 to 6 months minimum, in this applicant's case more. So again, I ask Your Honor to consider removing completely condition 4, both on this and the prior item as well. Thank you, Your Honor.
Thank you. Is there anyone else at public comment wish to provide information? Sir, you're the last one here, so I'm assuming that you have no public comment you wish to provide. Otherwise, you'd be standing up at this point. So I'll close public comment, bring it back to the applicant. Mr. Lear, could we have you back up, please, sir? Thank you.
Yes, ma'am.
Other than the gentleman, Mr. Ho, you can come up. Mr. Thaya, I apologize. You can come up as well if you choose to come up. That's fine. Other than your objection to condition number 4, do you wish to incorporate the staff report into your presentation specifically?
Oh, absolutely.
Okay, fine.
Yep.
Do you have any other testimony you'd like to present?
I would just like to make a comment on his comment, since it was post my testimony.
Sure.
And that he did state that, you know, the property is owned by the homeowner. The homeowner makes taxable payment to the county for said real estate taxes. The easement is there for future utilities, public interest. As we've identified, there is no future public utilities. There's no interest by utility companies. There is no interest in the public at all at this point, because all of the vacated plats to the left have already been vacated. So unless they're just going to install a pickleball court in the last portion of that gentleman's property and somehow make it right away for people, I just don't see that. He does make a point that, and I agree with him, the right of way is in the public interest. However, the homeowner and I have determined that that interest is no longer of public interest, and by the statute which I identified just earlier in my testimony, that I believe that based on that statute, if the city is not of interest at this point, and the homeowner's seeking, you know, everything up to that 6-foot requirement, that the property should be returned back to the homeowner for permits which have already been approved and inspected upon by the city. And yes, so that's it.
All right, sir, was there anything else you wish to testify to at this time?
No, we're good. Thank
Okay,
you,
fine.
Your Honor.
All right. Mr. White, you're up. Thank you.
Yes, Madam Hearing Examiner.
Anything further?
No further.
Okay, thank you.
Thank you.
I will take all the comments under advisement. Mr. Lear, I don't believe you've been here before, but I often say in these circumstances, time is money. And I clearly understand the circumstances of your client having issues with how the process is moving forward. Based upon that, I will try my best to get my recommendation as quickly as possible. It goes to City Council, as you well know, and then City Council will have an opportunity to do whatever it is that they think is in the best interest of the city.
Thank you
Okay?
for your time.
Thank you. So with those comments, I will close this hearing. The date and time of the next hearing is Tuesday, August 20th, 2024, 9 a.m. in council chambers. We stand adjourned at 10:36. Thank you, everyone.
Thank you.
Right on.